Delivery of judgment, item number 21.
RFN. 21 I will deliver at 2.
Item 22.
This revision petition is allowed, subject to payment of rupees 10,000 by the petitioner to the respondents.
May it be me, Lord. Lordship, I would like to mention item number 10, Lordship, hearing Lordship. In this case, may kindly pick in next Lok Adalat, Lordship. We are trying to solve it out, Lordship. The consent of the other side, Lordship.
Appeal is on the point of law, my lord. The claimant may try, but there is a doubt whether it will be settled or not.
Let us try Lok Adalat, otherwise.
We will send it for mediation. Is there any possibility?
Maybe
Medicine of the-
he
Why?
landed on his-
It may be, we try in Lok Adalat, Lordship, and
No.
if not, then.
We'll send it for mediation. Same thing. If there is a possibility of,
Lok Adalat is in 14-3, Lordship. If it is posted for Lok Adalat, then before that, 14-3 only just the date is coming.
heard Ms. S. Roy, learned counsel for the appellant. Also heard Mr. A. R. Agarwal, learned counsel for the respondent, as well as cross objector, who submits that there is an element of settlement in this appeal, and therefore prays for listing the same before ensuing Lok Adalat on
Scheduled 14-3, Lordship, scheduled to be held.
scheduled to be held on 14th of March. The prayer is allowed. Let this matter be listed in the Lok Adalat on 14th of March. Yes, Mr. Gogoi.
May it please, your Lordship, in respect to item number 18 and 19, Lordship. Today I have some difficulties. The part one matter is there, so Lordship, and I have already informed the respondent side, Lordship. Any day, Lordship, even tomorrow also I have no difficulty, Lordship.
No.
Any day, Lordship.
Heard Mr. K. Gogoi. These are not part heard.
No, these are not part heard, Lordship.
Okay.
These are not part
Heard
heard.
Mr. K. Gogoi, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the respondent, who does not have any objection to
I
this.
have just informed the senior counsel,
Prayer.
KP Maheshwari, Lordship.
Okay. The prayer is allowed. Let this matter be listed on 5th of
Lordship.
March.
Oblige, Lordship.
My lord, please. Item number 15 and 16, my lord.
14, 15.
14 and 15, my lord, today.
14 and
15, my lord. These are two analogous cases, my lord. My lord, I am for the respondent. I have a little percent difficulty today, my lord. It can be listed on any other day to the convenience of the.
heard Mr. A. B. Day,
I am the affiliate, my lord.
learned counsel for
The
the
consent of the other side, my lord.
respondent, who prays for an adjournment. The also heard Mr. R. C. Paul, learned counsel for the appellant, who does not raise any objection to the prayer for adjournment.
The 31st of March. Because in the meantime, they want to settle.
Okay. Let this matter be listed on 31st of March.
Deeply obliged, my lord.
May I please, my lord, I beg to mention item number 7 now. My lord, I am appearing for the respondent, my lord. I have taken the consent from other sides. That's what it is available. Sir. My lord,
Heard Mr. A. K. Gupta. Yes.
Sorry.
Heard Mr. A. K. Gupta, learned counsel for the respondent, who prays for an adjournment. On what ground?
my lord, I have some difficulty today.
On the ground of personal difficulty. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to same. So hence, the prayer is allowed. Let this matter be listed on 6th of March.
My lord, I have one another prayer, my lord, item number 26 and 27. My lord. 26 and 27. My lord, in this case, my lord, earlier, my lord, Mr. N.N. Upadhyay was engaged. He was appearing for the caveator, but yesterday he was detected some heart problem, my lord. My lord, now today morning, my lord, my senior, my lord, Mr. P.J. Sekia is engaged in this case, my lord. So I pray for, my lord, accommodation in this matter, and I pray that this matter will be taken on Saturday, my lord. My
You
senior
have-
friend is appearing for the appellant, my lord.
Who is appearing?
It's a very difficulty, my lord. Mr. Upadhyay appeared through a caveat. Then, Lordship may remember, yesterday, Mr. Bakchi said he has engaged by the party. Now, today, another council. Now, tomorrow, another council.
No, my lord,
Never ending matter, my lord.
my lord, yesterday, Mr. N.N. Upadhyay has.
I have no, we have no given consent, my lord. Only we can accommodate, my lord, for today.
Lordship,
Tomorrow,
take up on Saturday, my lord.
Saturday I will not be available, my lord.
My-
Tomorrow, Lord.
My lord, my senior has some medical appointments tomorrow, that's why the difficulty.
I'm-
Who is the lawyer?
Mr. P.J. Sekia.
I have a difficulty. Because
What is the matter?
matter is we came against an injunction order. It's a affair.
We'll fix it in the first week of March. Choose a date. They are afraid of you. They are changing lawyers. So accommodate them.
Also, with a stay, if it is faxed, we have nothing to say, my lord. Let the matter come up, my lordship, today. Lordship may kindly hear us, then
No, they are not ready. They have engaged.
then
in-
tomorrow, my lord.
On Saturday.
Tomorrow he is
He has some medical appointments, that's why I'm otherwise. my lord.
Saturday.
Saturday, my lord,
Saturday,
I'm ready for
I will be
Saturday.
available, my lord. I'll be having a medical consultant at Calcutta.
First week of March. Heard Mr. S. Deka. In 26 S. Deka, in 27 Mr. Bhaskar Datta Lanin, Senior Counsel assisted by Mr. Jitendra Das.
Then Saturday, my lord.
Lanin also had Mr. A.K. Gupta. Then
I'm appearing for respondent number 1 in both the cases.
Learned counsel for respondent number 1, who submits that the respondent has engaged Mr. P.J. Sakya, learned senior counsel in this case. Today only,
Today morning.
And he submits that the learned senior counsel for the respondent has some medical urgency and accordingly prays for listing this matter on Saturday, 21st of
Is it
February.
possible, my lord, only one accommodation? It's as a first item, my lord, because I have to catch up on the afternoon flight.
Okay. List this matter on 21st as the first item in the
Right.
cause list.
Now, today is wrongly listed perhaps, my lord, in the order column.
It may come up for
It's
admission.
just to be an admission column.
The first item in the cause list in the admission admission column.
Right.
Alright.
May I please your lordship? Your lordship, I am praying for listing of an IA. It is of 2018 delay application. Last time it was listed on 2012-23.
Date is the due. 2nd of March.
Oblige your lordship.
May I please, your lord? Lordship, I would like to mention for listing lordship one MSc appeal lordship for admission after delay conversion, it is not read. And two are in the orders column lordship.
2nd of March.
May please your lordship. Lordship, I am praying for listing of this LA appeal lordship in the admission column lordship.
LAP roster আছে আমার।
Next week lordship.
2nd of March.
Oblique. May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 11 lordship. Matter may be adjourned for the day, Lordship, as today there is some difficulty on the part of the.
My lord, at least they have appeared, my lord. I want that at least they should appear. My lord, 26, my lord, both sides, my lord, we have agreed. It may fix on 26.
No, choose a date on first week of March. 26, we have many cases.
Okay. My lord,
Any date.
my lord, I'm just.
Heard, Miss, what is your name?
Tip, my lord.
Miss B. Devi, Lordship, on behalf of.
Miss B. Devi, appearing on behalf of Mr. S.P. Chaudhary, learned counsel for the appellant, who seeks an adjournment due to personal difficulty. Also, Mr. G.N. Sahavala, learned senior counsel, appearing for the respondent, who does not raise any objection. Let this matter be listed on 5th of March.
Deeply.
May I please your lordship? Lordship, I beg to mention item number 20 of the daily list due to some personal difficulty on the part of my senior. Lordship.
You have informed the other side.
Yes, lordship.
Heard Miss J. Sharma, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Also heard Mr.
A Pator.
A.
Pator.
Pator.
Pator. Pator. A Pator.
A. Pator, learned counsel for the respondent, who does not oppose the prayer. Hence, the prayer is allowed.
Lordship, kindly fix a date.
Let this matter be listed on 5th of March.
Lordship, on 26th of March.
No.
Okay.
5th of March.
Obliged, Lordship.
I praise your lordship. Lordship, I'm praying for listing of an IA for orders, lordship.
Wait.
If possible, next week, lordship.
Second.
Obliged, lordship.
This Lordship, I will finish 17. Lordship, this matter is fixed for hearing. However, my senior is
Which item?
item 17. 17. Fixed for hearing. My senior is unable to appear due to his personal difficulty. I kindly seek for adjournment.
Item number 17. What is your name?
My senior is Dr. PN Popol.
Take the name. Learned counsel for the appellant prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed on 6th of March.
May I please your lordship? Lordship, there's an urgent listing of FAO along with the IA tomorrow for tomorrow.
Okay.
Actually,
On second,
no, actually, your lordship, during the pendency of the title appeal, the opposite party have illegally encroached upon the suit land. Now they are starting construction. So it's very urgent, your lordship, tomorrow if possible.
okay, tomorrow.
Much better.
Motion B, item 1.
Hey, please, your lordship.
You have made out some case.
My lord.
What is your ground?
My lord. Apart from grounds taken in my petition, my lord, I seek leave of this honorable court to argue on some additional grounds which is illegal, my lord, that the section 47 has not been complied properly, my lord.
No,
That
that
ground
is,
has not
that
been
is a
taken.
main ground. That has, if it is not complied, you have to take that ground in your petition.
Yes, but that has been taken, not taken, my lord. So if court permit that, my lord, I will. Otherwise, my lord,
No, you file an
I will file an additional affidavit.
additional affidavit.
In both the matters,
Both the
Okay.
matters.
arising out of the same matter.
Heard Mr. A.K. Azad, learned counsel for the petitioner, who seeks leave of this court to file an additional affidavit in this case to bring on record some additional ground for seeking bail by the petitioner. The prayer is allowed. When?
1 week, my lord.
Let this matter be listed on 6th of March.
Obliged.
Item 2.
Same order.
Same order.
Same order. Obliged.
For referring to some special medicine price, item 3.
My lord, it may be given is,
Referred.
yes. May be given in the 14th of, because the enhancement. We have an open. Hey, 7th of.
What is your name?
M. Sharma.
Heard Miss M. Sharma, learned counsel for the appellant,
Senior.
Senior advocate R.C. Saiki.
appearing on behalf of Mr. R.C. Saikia.
Senior advocate.
No, then your name is enough.
No, no, he's on behalf of,
Senior advocate R.C. Saiki.
I'm the respondent.
Who is assisting the, whom the senior advocate is leading in this case? Who is
Mr.
the,
R.C. Saika.
he is the leading lawyer.
Yes, yes.
Who is the conducting lawyer? Who is assisting Mr. R.C. Saikia? So your name is enough. Also admits Mr. R.C. Paul, learned counsel for the
Respondent number 3.
respondent number 3. It appears that there is an element of settlement in this case, and therefore this matter may be referred to mediation.
On 14th of March.
No.
Well, directly you can, it is an announcement, my lord.
You want it to be referred to Lok Adalat.
Directly, because there is a possibility of announcement.
The parties praise for listing this matter before ensuing Lok Adalat on 14th of March.
Right.
The prayer is allowed. List this matter before Lok Adalat on 14th of March.
Item 4.
That's it. In this case, actually, it was fixed for hearing. Here, 2 vehicles are involved. The present appellant has filed the appeal challenging their liability. 2 vehicles are involved and other vehicle is responsible. That is insured with New India. And in connected case, New India also settled the case taking full liability. So for national, it will be difficult to compromise.
That is not factually correct, Lordship. Here 2% died. 1 item vehicle and 1 oil tanker. Oil tanker insurer is the New India, and the Hyundai car is the national insurer. The driver of the Hyundai car also died. My client was the passenger. He was injured. The driver has settled the matter with the New India insurance. That court has not awarded anything. So that was settled.
Okay.
So that settlement,
But in this case, they are,
in this case, they have not adduced any evidence. Court has found that both the vehicle is involved, and the case of the claimant is also that both the vehicle has rash and negligence on the part of both the vehicle. So therefore, liability has been fastened to 50% to both the insurance. New India has deposited the 50% of their liability, but National has not deposited and filed this appeal. And while admitting the appeal also, nothing has been deposited. So I am suffering, I am the claimant. It's a fight between the two
no,
insurance.
is there any hope of
No,
amicable settlement?
amicable settlement, they said that New India has to pay. How New India will pay?
Okay, then let this case be listed for hearing.
Yes, Lordship. So that may be given, Lordship, the 2012 case, Lordship.
Okay. Heard
Here is clear, Lordship.
Mr. A.J. Saikia, learned counsel for the appellant. Also heard Mr. S. Deka, learned counsel for respondent number 1/claimant. It is submitted at bar that this is not a fit case to be for referring the same to mediation, as they also submits that the case is ready for hearing and needs adjudication by the court after full hearing. The prayer is allowed. Show the name of Mr. K.K. Bhatta also as respondent number 3. Let this matter be listed for hearing on 5th of March. On 5th of March.
Item 5.
May it please your lordship. Lordship, this matter cannot be settled in the mediation.
Any submission?
No objection, we will contest the case.
Heard Miss
Psychology.
M. Sakia, learned counsel for the appellant. Also heard Miss, what is your name?
B. Chaudhary,
B. Chaudhary,
respondent number 1 and 2.
learned counsel for respondent number 1, 2, and 3.
1 and 2 only.
1 and 2.
Yes.
It is submitted at bar that this is not a fit case for referring the same to mediation. I have gone through the materials on record. Considering the submissions of learned counsel as well as after perusal of the materials on record, this court is also of considered opinion that since the matter is ready for hearing, this court is also of considered opinion that this is not a fit case for referring the same to mediation. Stop. Since the matter is ready for hearing, list the same for hearing on 26th of March.
Obliged.
Item 6.
Please, your lordship. Lordship, this case is not fit for mediation. And it needs to be.
Any objection?
I have no objection because I'm the here driver, Your Honor.
Lordship, the vehicle in question is implanted for illegal gains.
Your insurance company?
Yes, your lordship.
Okay. That Mr. R. Sharma.
Yes, sure.
Your Lord, preparing for respondent number 1 to 4.
Yes, Sharma. Also heard Miss, what is your name?
A.G. Chaudhary, Your Lordship.
A.G. Chaudhary, learned counsel, appearing for respondent number 1 to 4. And Miss S. Khatoniar, appearing for respondent number 6. It is submitted at bar that this is not a fit case to be referred to mediation. After going through the materials on record, this court agrees with the submissions made by learned counsel that this is not a fit case to be referred to mediation. What is the status? Service is complete.
Yes, in the year 2024.
List this matter in orders column. We are fixing it for orders column.
It can be fixed for hearing,
It's
Your
for
Lordship.
hearing, I think.
It is submitted. No, list this matter for hearing on 31st of March.
That be so. Item 23 from supplementary list.
This is an appeal against injury case.
Heard Mr. R. Goswami, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and award dated 23/7/2025 passed by the Motor Accident Claims Tribunal, Jorhat, in MSC case number 3/2022. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. The appeal is admitted. Let the records of MAC case number 3/2022 be called for from the concerned tribunal registry to take steps for requisitioning the records. List accordingly. You are paying 50%. Heard Mr. R. Goswami, this interlocutory application has been filed under Order 41, Rule 5 of the Code of Civil Procedure 1908, praying for stay of execution of the impugned judgment and award dated 23/7/2025, passed by the Motor Accident Claims Tribunal, Jorhat, in MAC case number 3/2022. the learned counsel for the applicant has submitted that the applicant has impugned the aforesaid judgment and award in the connected MAC appeal number 66/2026, which has already been admitted for hearing and notice to respondents have been issued. Learned counsel for the applicant further submits that the insurance company is ready to deposit 50% of the awarded amount as a condition for stay of the execution of the impugned judgment and award. In view of the fact that in view of the aforesaid submission, notice to the respondent is waived in this interlocutory application, and the prayer made by the applicant is allowed. The execution of the impugned judgment and award passed in MAC case number 3/2022 by Motor Accident Claims Tribunal Gauhati is hereby stayed, subject to deposit of 50% of the awarded amount, within bracket, the awarded amount of rupees 30,08,800 bracket close, to the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
The A on quantum, the respondent number 2 and 3 may be struck off. Although they have received notice earlier in the earlier.
Now let us see. You first take steps in make appeal. This we are disposing of. In appeal, you take step by speed post. No, striking out at this stage. First, you take steps. If they don't appear after the receipt of notice, then we may strike it out.
Orders, item 8.
May I please, Lordship, we are appearing for the respondent, claimant 1, 2, and 3.
Address ready regarding service and records, Lordship.
May I please, Lordship, I think this case has elements for alia, so it may kindly be referred to the ensuing Lok Adalat.
Yes.
Okay. Heard Mr. M. Sakya, learned counsel for the appellant. Also heard Mr. R. Goswami,
1, 2, and 3.
appearing for respondent number 1, 2, and 3. It is submitted at bar that there is a possibility of reaching an amicable settlement in this appeal between the parties, and therefore a prayer is made for referring the same to the ensuing Lok Adalat on 14th of March 2026. The prayer is allowed. List this matter before ensuing Lok Adalat on 14th of March.
Item 9.
Lordship, I'm appearing for respondent number 1 and 2 on behalf of Mr. KK.
This I is for main appeal to the yes, I is for
Matter kindly taken at 2 PM. My senior is late at another 4.
no.
I think.
Why the I is for?
Lordship, I is filed for early hearing. We have not kept it a copy, I have seen the record. Or fixing a date for early hearing.
We'll fix a date.
I think that the petition. It's in the-
You have any objection to this? You don't have. What is your name? Be louder. Heard Miss Shehnaz Parveen, learned counsel for the applicant in IS Lobo. This interlocutory application has been filed by the applicant/appellant praying in connection with the connected MAC appeal number 789/2020, praying for an expeditious hearing of the connected appeal. Staff also heard Ms. M. Chaudhary, learned counsel for respondent number 5, as well as Mr. S. Sharma, appearing for.
On behalf of KK Bhatto for responding number 1 and 2.
Appearing for respondent number 1 and 2. Learned counsel for the respondents do not have any objection to the prayer made in this interlocutory application. Hence, this interlocutory application is allowed. Let the connected MAC appeal be listed for hearing on 31st March. In MAC appeal, in view of the order passed in IA number 2580/2025, let this matter be listed, let this appeal be listed for hearing on 31st of March.
Grateful.
Item 24 and 25 from supplementary list.
May I please,
Yes.
Lordship, in item number 24, this appeal has been filed for the by the claimant for enhancement. As because Lordship, the monthly wage has been taken as 6,000 without considering the day.
No, I'm not getting it. What happened?
Lordship, there are two appeals. One appeal is filed by us and the other appeal is filed by the claimant, Your Lordship. In both the cases, probably service is completed, Your Lordship.
It is already fixed for hearing.
Yes, it may be heard, Your Lordship. A date may be fixed for hearing,
So we'll fix it.
Lordship.
It is already an order for.
Lordship. In item number 25, Your Lordship, I am the appellant.
Write the name of the parties. Mr. I. Hawk for appellant in item number 24. Mr. R. Goswami for respondent.
Lordship, I am appearing for respondent number
No,
1.
Mr. P. Thakur for respondent number 1. And in item number 25, Ms. P. Thakur for the appellant, Mr. P. Hajorika for respondent number 3 and 4, and Mr. I. Hawk for respondent number 1. It is submitted at bar that both these appeals are ready for hearing and may be taken up together for hearing. In view of the submissions made at bar, let these matters be listed for hearing on 2nd of April.
Oblige, Your Lordship.
Item 28.
May I please, Lordship? Lordship, I have for 17 days delay condemnation.
Mr. What is your name?
Yes, Ahmed.
J.S. Ahmed, learned counsel for the applicant. This interlocutory application has been filed under Section 5 of the Limitation Act, praying for condonation of delay of how many days?
17 days.
Of 17 days in preferring the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30 March.
Hearing item 12.
Maybe your lordship.
Yes.
Your lordship, in this case, the evidence is not with me, your lordship.
Evidence is not.
With me, evidence of the parties.
They are
I
appealing the
require-
order. Ground has been met.
You are not
It is
ready.
not, actually, I have no contact with the party. Maybe with the party or lordship. Sometime may be granted, I'll bring those documents. your lordship.
It's a partisan.
Some of the documents, some of the evidence given by my learner friends, I'll gather, the date may be fixed, your lordship.
It's a partisan suit
Yes,
between
it is
brother and
partisan suit.
sister.
I-
Neither relation is denied, neither nor ancestral right is denied.
Then why
Nothing is
don't
denied.
you reach an amicable settlement?
That can be done. Your
There is
Honor,
a
if,
possibility of your brother and sisters.
Yes,
your
Lord.
lordships.
Then go for mediation.
Everything is in admitted condition. If
Then why you
allow
fight
me-
out?
Allow me to read the DW 1 and 2. All are admitted.
No, let him prepare his brief. And in the meanwhile, we are referring this to mediation.
Date may
We
be.
will fix a date.
Your lordships, in the meantime, if it is referred to mediation, your lordships, a notice may be issued.
Notice the mediation center would be issuing notice.
To the party, your lordships.
It may take time. my lord.
You are in touch with your client.
I am plaintiff in original suit here.
Your
You are-
brother or
I am in. Good condition.
when
don't-
he is in touch, why you are not in touch?
Because of the 7-8 years.
Same is the thing for him also.
Phone number also is not here, your lordship, so.
He will give you the phone number.
He's not giving me the phone number.
No,
your lordship.
No, give him the-
Communication is not good at all. Recent number is also not with the respondent side. That is why.
The brothers and sisters are not in speaking terms.
No, Lord, sir, not at all. Since 2014.
Since 2014.
14.
Litigation, litigation
then-
established, your lordships.
14.
14.
Then come prepared for hearing.
Problem is this, your lordship, in this case, your lordship, there is a statement in the plant that they about to relinquish the property, everything he relinquished. Later on, what happened to the sister, they come up with this partition suit.
No.
So these are the problems because of which there is no topic.
Heard Mr. N. Jha, learned counsel for the appellants. Also heard Mr. R. Ali, learned counsel for the respondents. It is submitted by learned counsel for the appellants that he has misplaced the
Different parts.
evidence of the witnesses which would be necessary for making submissions in this appeal, and therefore seeks some days' time so that he may collect the same. The prayer is allowed when?
No, it may be kindly consider it
In the meantime,
February,
mediation-
February itself, Your Lordship.
No, not February. February, nothing. March, you
March
choose a
second
date.
week, Lordship, 11th of.
Choose a date.
March, your lordships,
It's 10th
March.
of March.
Let
no,
him choose.
March on the last part, your lordships, if possible. 26, 27,
Suggest a date.
24 Tuesday.
24, your lordship.
Learned counsel for the appellant prays for listing this matter on 24th of March. The prayer is allowed.
And the bar may be made on that day, Lordship. Is for the.
No, therefore I have reflected that it is on his prayer. We are fixing
Your
that.
lordship, I'll be ready on 24.
List this matter on 24th of March for hearing.
Item 13.
Yes.
Your lordship.
What is this?
This appeal is filed underground that accident occurred at a time when the policy was not effective. There is a policy
Policy was not effective.
effective. Denying that there was a policy. There is a policy. Now, so what happened is this policy was taken on 26th of November 2007 at 1 PM.
Just a minute.
Lordship may come to judgment para number
26th of November.
2007. Very old matter.
Yes.
Giving an effective date from next day, Lordship, 27/11/2007 at 1 p.m. Exactly 24 hours thereafter. It is stipulated in the policy that the accident occurred on 26/11/2000 at 5 p.m. 5.15, 5:15. This is the bone of contention, Lordship. Where the policy was effective at the time of occurrence of the accident. The policy was issued on 27.
This issue was raised. This issue was raised before the tribunal also.
Yes, Lordship. They had given evidence.
What was the findings?
Lordship may come to issue number 2, judgment page 7.
Yes.
For deciding issue number 2, it would be necessary to appreciate the claimant's witness as well as that of DW1. DW1 is one Bitupon Gogoi working as legal manager.
What was issue number 2?
Lordship. Issue number in page 7, Lord. What is that?
Okay, whether it was duly insured. Yes, please read.
DW1 is one Bitupon Gogoi working as legal manager of the Gauhati branch of the OP number 3, Reliance General Insurance Company Limited. During his short examination in SIF, more particularly in paragraph number 2 thereof, the DW1 has stated that the vehicle involved in the accident bearing registration number so-and-so was not covered by any insurance policy during the relevant period of accident. As such, the Reliance General Insurance Company is not liable to compensate the claimants in the present claim petition. DW1, along with his affidavit, filed and submitted a copy of the proposal cum cover note for package policy in respect to the aforesaid bus. In the aforesaid proposal cum cover note of OP number 3, Reliance General Insurance Company Limited, the vehicle number has been mentioned as so-and-so, engine number so-and-so has been mentioned. The aforesaid cover note with the seal and signature of the authorized company was issued at Dinhata on 26/11 at 1 p.m. However, in the cover note, it has been specifically mentioned that the policy's effective date and time of commencement would be 27/11/2007 at 1 p.m. and that the expiry would be on midnight of 26/11/2008. It is the admitted case of both the parties, which is also revealed from the accident information report in Form 54 that the accident occurred at 26/11/2007 at 5:15 p.m. From a bare reading of the proposal cum cover note, it is apparent that the insurance company received the premium and issued the cover note on 26/11/2007 at 1 p.m. However, it was mentioned and stated that the policy would be effective from 1 p.m. of 27/11/2000 till midnight of 26/11/2008. The learned counsel of the claimants has argued and submitted since the insurance company has received a premium of rupees it should be 4 and issued cover note on 26 at 1 p.m. The accident occurred after 1 p.m. That is about 5:15 p.m. The insurance company would be liable to indemnify the liability of the owner of the vehicle. On the other hand, the learned counsel of the insurance company argued and submitted that as the date and time of commencement of the insurance policy has been specifically mentioned,
to be 27/11/2007 at 1 p.m. Notwithstanding the fact that the insurance company having received the premium and issued the cover note at 1 p.m. of 26/11/2007, the insurance company is not liable under law to indemnify the liability of the owner of the vehicle in terms of the special contract of insurance, that is insurance policy. Thereafter, Lordship, it is in this regard, the tribunal has come across certain decisions to the Honorable Supreme Court, Lordship. These have been discussed, and finally it came to a conclusion that insurance company is liable.
Now, what is your contention?
My contention, Lordship, it says whenever there is a special term in the insurance policy, the judgment ordinarily that would have been appreciated, but Lordship, I just rely on this particular suggestion. It's a three-judge bench decision. There are other decisions, there are various decisions under subject matter. But I find in my case, we should appropriately cover this.
Putul, like, Mera?
Para number 2, Lord, there is one major para is decides the principle, refers to other various decisions of the. So unless this is revoked, Lordship, this by a higher bands, I think this will apply.
Please read.
May I read, Lordship? In this appeal, the correctness of the decision of a two-member bench of this court reported in New India Assurance Company Ramdayal is required to be tested. The facts giving rise to the appeal are minimal. The appellant insurance company sold a policy at about 4 p.m. on 17/12/1989. Undeniably, it had been bought at a time when an accident pertaining to the vehicle insured had already taken place at about 9 a.m. of the same day.
So in this case, the insurance policy was brought
Yes.
after the accident.
Correct. But I'll still come to the question, what if a time is mentioned from when it will be? The fatal accident occurring thereby gave rise to a claim for damages before the Motor Accident Claims Tribunal. The same was allowed on the strength of a decision of this court aforementioned, correctness of which has been challenged. The said decision preceded on the legal fiction that when a policy is taken on a particular date, its effectiveness would start from the commencement of that date, which is from the previous night, midnight. The accident having taken place at any time during the day would be covered by the policy. The later, a three-member bench of this court in National Insurance Company versus Jikubai Nathuji Davi has taken the view that when there is a special contract mentioning in the policy the time when it was bought, it will be operative from that time and not fictionally from the previous night, midnight. In that said case, the policy had been brought at about 4 p.m. on that day of the accident and was thus not allowed to be speculative from operative from midnight. The accident having occurred at 11 a.m. on that day. The principle deduced is thus clear that there should be no contract to the contrary. That should there be no contract to the contrary, an insurance policy becomes operative from the previous midnight. Because normally it should be operative from the previous midnight if there is no contract to the contrary. However, in case there is mention of a specific time for its purchase, then a special contract to the contrary comes into being, and the policy would be effective from the mentioned time. The law on this aspect has been put to rest by this court. Thus, there is just nothing further for us to deliberate upon. In this case, it is a special contract in the sense there is a special time mentioned in it. Normally, it says, should there be anything to the contrary, it will be operative from the midnight of that particular day. That means even if policy is taken now, it will be operative from the midnight. That means from 1 AM, 12 PM. That is the usual. Should there be any to the contrary? Should there be no contract to the contrary, and insurance policy becomes operative from the previous midnight.
Okay.
When brought during the day following. Previous midnight means from 12 PM, Lordship. And if it is bought during the day, 11, 12, 1, 2 PM, it will be operative from the previous midnight. That is from here. However, in case there is mention of a specific time in a forest purchase, then a special contract to the contrary comes into being. Now a special contract comes into being because time is mentioned.
No, but time of purchase was earlier than time when.
That I live, but here I'm saying if the, now it says a special contract means a contract mentions a particular time. It's for sanctity of that particular year, the why a particular time was proposal form that was taken at with his consent. Proposal form is signed by the Lordship insured. It's a proposal form come covenant. So if he has also agreed that it will be operative from 1 PM of the next day. Nothing is usually taken earlier. This policy used to be there. The governors are issued in supposing in a village, someone wants to take a insurance. Premium would be received the next morning. So for all this, there can be various companies. By the time the agent reaches the office, there might be some time consumed. Insurance company would not even be able to verify whether this policy can be taken or not because some agents spread throughout the year. It's a policy which the office which decides the acceptability of a year. So I think this were put as a matter of caution, Lordship. People come to the office and they, I think, give it from the same day. This is a practice, a standard practice that used to be followed. It's not unique in this case because there are several judgments on this particular point, Lordship. So several cases it has reached Supreme Court. Decisions are there. But this when there is a special contract, it's not like an ordinary contract, insurance, that it starts from the year.
Okay.
It gives a date. Ordinary Lordship, I may be allowed to clarify. It starts from the day when the policy is taken.
From the previous midnight.
Answer is special time is incorporated. And I think to overrule this Lordship, there has to be a different ruling by Lordship.
Okay. Yes, Mr. Abha.
Mayor, Mr. Lordship. There is only one time factor. It is undisputed that the premium was paid at 1 PM. An accident took place after 4 years,
4 hours.
That means 5:15. It is clear that premium was paid ahead of the accident on the same day. Now the question is, even the insurance law also is very clear that it is doesn't mention in Authorised also, but here it is very specific. The law is very clear that for the purposes of this section.
Where are you reading?
Lordship.
Where are you reading? Which?
It is insurance policy, page number 133. And rule section 64 BV.
Section?
Here, the law provides that for the purpose of this section, that means no risk to be assumed unless premium is received in advance. It relates to that. For the purpose of this section, that means relating the payment of advance payment of premium. For this purpose of this section, in the case of the risk for which premium can be ascertained.
No, which section you are reading?
Lordship, it is 64.
64.
Yes, 64 PV.
Of MV Act.
Yes. Insurance Act.
Oh, 64 V.
PV.
VB.
Lordship.
Just a minute.
The risks may be assumed not earlier than the date on which the premium has been paid.
There is no
Not earlier
64
than,
V.
but here also, that means it commences from the date. It was 64 GB, 133 pages. Section 2.
Yes. Please read.
Subsection 2, 64 VB subsection 2. For the purpose of this section, in the case of risks for the which premium can be ascertained in advance, the risks may be assumed not earlier than the date on which the premium has been paid in case or by check to the insured. The point is that at least from the date of premium, not later or not earlier. On the date, that means date of payment of premium.
Okay.
So here, Lordship, accident took place 11.
No, here their
21,
contention is different.
26/11/7 at 1 p.m. At premium is paid at 1 p.m. but accident took place at 5 p.m. Earlier than that, that means it as per law provides the premium will be effective from that date. That means 16/11/7.
But in your insurance policy,
Proceed.
a specific
Contract.
to the effect that it will be effective from next day. What will happen to that clause?
Yes. So on that point, my point is that actually the law is very clear that not it must be actually normally previous day, previous midnight. Normally it means it is effective on the previous day. But here this condition is so not so defeating that it will commence after next day. That means 27. It is impossible. It is not legally acceptable.
On this issue, there is no, do you have any authority?
Even it is a contract. The contract, there is a specific contract law also is there, where it says that contract condition is not acceptable when that has a what consideration and object and lawful and what is not. It is a contract. Contract is unlawful. It cannot be considered when it involves implies injury to the person. Here in normally is not well because if we accept the condition that it will affect from the next midnight, it is not a consideration, it is not lawful, and it will implies the injury to the person. And the act itself is a welfare. So it will affect the public policy also. Here, the court again regards it as immoral or opposed to public policy. The punishment is goes against the public policy. The very public policy of this act, it is welfare, public welfare. So it goes against the public policy also. So this condition that it will be effective from the next midnight, it is against both the public policy.
Anything else?
So my respectful submission that the three bench the judgment was delivered way back in 1999. That means on 10 February 1998. But subsequently, the Honorable Apex Court also, at Horomsan, was of the same fact, almost that was allowed in just like similar case, the compensation was allowed from Sun. It is quoted in the judgment also. And on that ratio, the learned tribunal awarded the compensation. Romson was delivered on August 27, 2010. And this, the judgment that was.
What was held in Dharamchand?
It was 1998.
No. This judgment already they have given.
During the record, earlier, submitted.
Yes, Mr. Goswami, anything?
But sir, Dharamsingh,
Here, the case which you have cited, facts are little distinguishable, slightly distinguishable in the instant case. What I understand is that though a time when the policy was bought, when it was purchased, has been mentioned, but there is also a mention about the time from when it will become effective. But in the cases cited by you, there was no such subsequent time of giving effect to the policy. In the cases cited by you, the question was as to whether it will be effective from the previous night or from the date of time of purchase. The apex court in the judgments relied upon by you says that it will be effective from date of purchase, time of purchase. But in this case, he is relying on a different point. On that, do you have any submission? Suppose date of purchase is 1 p.m. and in the policy it has been specifically stated that it will be given effect on from the next date. On that, you have made only one submission that it will be against the public policy. Any other submission? Mr. Goswami, you want to?
This Dharamsin's lordship was made on the basis of a concession made by the council of the insurance company.
Yes.
And that is not a wrong year. It's under suggestion. It says under suggestion made by the insurance company.
That was appreciated. That was appreciated by the apex
Yes,
court.
lordship, but that does not lay down. It's a wrong concession made by the. And in any case,
But
three other judgments of
apex court said that it was not wrong concession. It appreciated that it was a fair submission.
because the concession was made, it was appreciated, lordship. Lordship, there are two judgments. I'm giving two judgments of three judgments and also one division that reiterates the same, dear lordship. These are again under three judge bench decision. The full bench decisions are there, lordship. That was also three judge under three judge.
What it says?
Same, supporting the same, the special contract. Again, this under one thing.
No, the judgment which you have relied.
Yes, lordship. It says the special, if there is a special contract, then time must be taken from the time mentioned in the year, lordship. Contract. Normally it operates from midnight. Usually, should there be no contract to the contrary, it will operate from the midnight, previous midnight.
Okay.
But if there is a, there may lordship be allowed to place this judgment also.
No, if it is on the same point.
Lordship, let me reinforce, lordship. And reason.
With judgment.
Small judgment, lordship, on the same point.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. This is item number 13.
For the claimant, that's my number 1 to 4.
Also heard Mr. Rabha, you are for?
I am for 5 and 6.
Mr. D. Kolita, appearing for respondent number 1 and 4. Mr. U.C. Rabha, appearing for respondent number 5 and 6. This appeal under section 173 of the motor, you may take your seat. Appeal under section 173 of Motor Vehicle Act 1988 has been preferred by the Reliance General Insurance Company Limited, impugning the judgment and award dated 5/10/2015 passed by the Motor Accident Claims Tribunal, Dhubri, in MAC case number 297/2008, whereby the appellant was directed to pay a compensation amount of rupees. What was the total compensation amount? Amount of rupees 4,56,800.
I'll give the exact.
To the claimant,
56,800.
to the claimants, along with the interest at the rate of 6% per annum from the date of filing of the claim petition till realization. The facts relevant for consideration of the instant appeal, in brief, are that on 26/11/2007 at about 5:15 p.m. when the husband and father of the husband of claimant number 1 and father of rest of the claimants respectively was namely Lakhi Kant Roy was coming to his house from Ratia Daha Bazaar on his bicycle, a super bus bearing registration number WB633017, which was going towards Gauripur from Boxir Hat and being driven in a rash and negligent manner, knocked him on National Highway number 31 from backside stop. As a result of the aforesaid accident, Lakhi Kanto Roy sustained grievous injuries. He was immediately taken to Dhubri Civil Hospital. However, on the same day, he succumbed to the injuries sustained by him in the accident. The present respondent number 1 to 4 preferred an application under section 166 of the Motor Vehicle Act 1988 before the Motor Accident Claims Tribunal Dhubari, claiming compensation for death of Lakhi Kanta Roy in the aforementioned vehicular accident. The motor vehicles, the opposite parties, the appellant being opposite party number 3 in the aforesaid claims case, contested the claim by filing written statement therein. Stop. During the inquiry, on behalf of the claimant side, 2 witnesses were examined, whereas the present appellant adduced evidence of one Bitupan Gogoi. However, by the impugned judgment and award, the claim was allowed and the compensation was awarded to the claimants in the manner as already described in foregoing paragraphs. Stop. Learned counsel for the appellants, Mr. R. Goswami, has submitted that the main issue to be decided in this appeal as to whether when a specific date of giving effect to the policy has been mentioned in the cover note of the insurance policy itself, then whether the policy would be effective from the said date or from the date when the said date and time, or from the date and time on at which the policy was bought or purchased. He submits that in the instant case, the premium of the comprehensive policy in respect of the offending bus was purchased by the owner of the offending bus on 27/11/2007 at 1 p.m. and it was stated in the policy that the said policy would expire on the midnight of 26/11/2008. He further submits that though the date and time of the accident in which the husband of the respondent number 1 died is not disputed. Stop. He submits that the present appellant is not disputing the date and time mentioned in form number 54. Date and time of the accident mentioned in form number 54. That is at 5:15 p.m. on 26/11/2007. However, he submits that it was clearly mentioned in the cover note of the policy that the policy would be effective from 1 p.m. of 27/11/2007 till the midnight of 26/11/2008. Thus, he submits that the date of the policy becoming effective was the next date when the offending bus met with an accident. He submits that as there was a stipulation in the policy itself to which the insured also agreed to at the time of obtaining the policy by putting his signatures. Hence, the general rule that the insurance policy would be effective from the date and time of purchase would not be applicable in this case. He submits that the apex court has, in a catena of judgments, made it clear that when no specific time has been stated as to when the policy was bought, it would be operative from the previous midnight of the day when the policy was bought. However, if there is a specific contract to the contrary, giving a stipulating some other date and time for policy becoming effective, then it would be effective only from the time specifically mentioned in the policy. In support of his submission, he has cited following rulings. Number one, New India Assurance Company Limited versus Bhagwati Devi, reported in 1998, 6 SCC 534. Number two, National Insurance Company Limited versus Jijubhai Nathuji Dabhi and others, reported in 1997, 1 SCC 66. Number three, New India Assurance Company Limited versus Srimati Sitabai and others, reported in 1999, 7 SCC 575. Next number. National Insurance Company Limited versus Sobina Ikai, IAKAI and others, reported in 2007, 7 SCC 786. He therefore submits that the Motor Accident Claims Tribunal Dhubri erred in allowing the claim case filed by the respondent number 1 to 4 by overlooking the settled law as settled law in this regard, and therefore he prays for allowing the instant appeal and setting aside the impugned judgment in award. Stop. On the other hand, learned counsel for the complainant and the respondent number 2, 3, 4 and 5. No, learned counsel for respondent number 1 to 4, namely Mr. U.C. Rabha.
For respondent number 5 and 6. For respondent number 1.
No, Mr. D. Kolita. D. Kolita, Mr. appearing for respondent number 1, 2, 3, 4, as well as Mr. U.C. Rabha, learned counsel for respondent number 4 and 5, has submitted that the trial court has rightly awarded the claim case filed by the respondent number 1 to 4 in terms of the prevailing law, and same is not required to be interfered into in this appeal, and they pray for dismissing the appeal. It is submitted by learned counsel for the respondents that as per section 64, V for van, VB, Vellore and Bombay. 64 VB within bracket 2. The risks for which premium can be ascertained may be assumed not earlier from the date on which premium has been paid in cash or by check in the insurer to the insurer. He submits that in the instant case there is no dispute that the premium for the insurance policy was paid on 27/11/2007. No, on 26/11/2007 at 1 p.m. And the authorized signatory of the company had issued the premium on the said date and time. They also submit that there is also no dispute that the accident occurred in the evening of the date when the purchase premium was bought at about bought stop. They submit that the policy was purchased, premium of the policy, they submit that the policy was purchased at 1 p.m. by paying the premium on 26/11/2007, whereas the accident occurred after about 4 hours at 5:15 p.m. on 26/11/2007. They submit that the judgments of the apex court cited by the they submit that in this case, in this regard, the apex court has also made it clear that the policy, that the insurance policy would become effective from the time which is mentioned in the policy regarding purchase of the said policy. Stop. In support of their submission, they have cited following rulings. Before that. Following rulings. Number 1, State of Madhya Pradesh and another versus Medha. Sorry. The number 1, Oriental Insurance Company Limited versus Dharamchand and others, reported in 2010 15 SCC 141. Number 2, New India Insurance Company Limited versus Bhagwati Devi and others, reported in 1998 6 SCC 534, stop. Mr. UC Rabha, learned counsel for respondent number 5 and 6, has also submitted that when the policy was purchased on 26/11/2007 at 1 p.m., providing for a stipulation for making the policy effective from a subsequent date, that is 27/11/2007, would be against the public policy as well as legislative policy contained in the Motor Vehicles Act, since the Motor Vehicle Act 1988 is a beneficial legislation. Providing for relief to the persons who suffers in motor vehicular accidents. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Reserve. I am reserving the judgment.
So that Gauhati's decision has been cited by me also.
Yes. New India Insurance versus Bhagavati Devi.
Yes, that is relied upon by me.
This is by you.
Man,
Tucci.
like 3 full bench decisions.
Mr. Kolita, you have cited only one judgment.
10 judgment.
Okay. Bhagavati tu second judgment to উপৰত দেখাই দিব. Heard Mr. Partisan নাম লিখি, hearing concluded, judgment reserved.
Obliged.
Otherwise.
নামিকা আজিয়ে লৈ ল'ব, আজি ইভিনিং লৈ ল'ব.
Item 16.
Yes.
Okay, Lordship, in this case, we have challenged the quantum of
Quantum.
Yes, Lordship. Lordship, in this case, this income certificate issued by the circle officer was exhibited before the court, but no official witness was examined to prove the said certificate. And the learned member assumed the monthly income of the deceased as rupees 19,500. No trade license, no GST registration, no bank statement, no books of account, no income tax return were exhibited before the court. And as per the claim petition, the claimant had a vehicular business. On the
What business?
That's it.
Claimant had what business?
As per the claim petition, the claimant had vehicular business.
Vehicular.
Vehicular business.
Means?
Means he had it 2 trucks. He had 2 trucks. But as per the income certificate issued by the circle officer, this is had a stone business. What's it kindly see the judgment? Page number 20. In my memo of appeal list,
Page number?
20. Para 11 from the judgment. It is the claim of the claimant that the deceased was a businessman of the vehicle and used to earn rupees 20,000 per month in support of year of produce and income certificate marked as Exhibit 16. It appears the Exhibit 16 is issued by the circle officer certifying annual income of the deceased as rupees 3 lakhs. Learned counsel for the insurance company argued that the said certificate cannot be relied upon because of the claimant have claimed that the deceased was a vehicle businessman, but the circle officer certified that the deceased was doing a stone business and others. Therefore, this court cannot rely exclusively upon the Exhibit 16, but has to assess the just and reasonable income. In this case, no adverse evidence is available before the tribunal to opine that the deceased was unemployed. The deceased was a guardian of five family members, including him. Moreover, Exhibit 17, Exhibit 18, and Exhibit 19 revealed that the deceased was the owner of the 2 commercial heavy goods vehicles, in addition to a motorcycle. So this court relies on the claim of the claimant that the deceased was a vehicular businessman, and considering the point of the time at the rate of inflation in transportation sector, opines it would be reasonable to fix rupees 650 per day as income of the deceased from heavy goods vehicle. Hence, this tribunal arrived at a monthly income of rupees 19,500, which is not beyond ground of reality, rather just unreasonable in case of the vehicular businessman. The claimant had a wife and 3 children.
In the circle officer's certificate, what was the income shown?
Income was shown rupees 3 lakhs per annum. And
That-
the claim
That was not taken into consideration.
Listen, that was not taken into consideration.
Court made its own assessment. The tribunal made its own assessment on the basis of other.
Exhibit 17, 18, and 19.
As per the claim petition, monthly income was rupees 20,000. As per the circle officer certificate, annual income of the deceased was rupees 3 lakhs. And court considered at rupees 19,500 per month.
$19,500 per month. How much it comes annually? Use your mobile. How much the annual incomes?
1,80,000.
1,80,000.
That's
80.
180.
Okay, what else is your submission? Yes, continue your submission.
Lordship, in this case, because also no documents such as trade license, GST registration, bank statement, books of account, and income tax return were not exhibited before the tribunal. Only on the basis of the Lordship registration certificate of the vehicle, which were exhibited before the court, the court assumed the daily income of the deceased as rupees 650. So, Lordship, where there is a contradiction regarding the business. In one side, he has claimed that he has a vehicular business, in another side, he has claimed that it was a stone business. So there was serious doubt about the genuineness of the income certificate. And that's it, adverse inference under section 114 of the evidence act should be drawn. The learned tribunal failed to appreciate this contradiction and mechanically accepted the income as shown in the exhibit 16. So my humble submission is that instead of rupees 19,500, they could have to consider notional income of the deceased as rupees 8,000 per month, when there was no positive evidence to prove the income of the deceased.
Okay. Yes, Mr.
Lordship. My submission is that there is no infirmity in the judgment and award passed by the learned tribunal, Lordship. The deceased was having two heavy goods vehicles. And it is clearly stated in their in his affidavit also, the claimant stated in paragraph 4 that the deceased was having two heavy vehicles and used for carrying stones and bricks. Also, you can see paragraph 4 of affidavit. Lordship.
Para 4
Income.
of the affidavit in the before the tribunal.
Tribunal, Lordship. That is not disputed, Lordship. Thus, amount of rupees 650 per day carrying the business of vehicles, two heavy vehicles, is on the lower side, Lordship. And learned tribunal rightly considered the exhibit 17, 18, and 19. That is, registration certificate has been exhibited, Lordship.
What are the exhibit 17, 18, 19?
17 is the registration certificate of motorcycle. 18 and 19, two heavy vehicles, trucks.
Anything else?
Lordship, only they have challenged the income. So, paragraph 11 is very clear, Lordship. They're taking the ground that the exhibit 16 has been wrongly considered. But learned tribunal has not considered exhibit 16. Learned tribunal has considered exhibit 17, 18, and 19. Hence, amount of rupees 650 only in case of two heavy vehicles is on the lower side, Lordship. Lordship, can we see, may I read again that element?
No, not necessary. Anything else you want to say?
No, I have nothing to say. Lordship. Only that point is
Mr.
there.
Bhatto, anything?
Want to submit to decision also. On its
What? Which para? What? Why you have? What you are relying on?
para number 21
On-
in the 2025 legal Gauhati 153 আছে Deepak Kolita versus division bench and others.
Para number?
Para number 21. Regarding income of the claimant, in the income certificate was issued by the circle officer of Material Revenue Circle. However, the claimant has not given any which for the nature of the business by which the income was calculated rupees 1,20,000 per annum. Hence, authority was issued the income certificate is also not produced before the court explained by the claimant. It is also not explained as to what under what authority or how the said income certificate could have been issued by the circle officer, Material Revenue Circle, or how it come to a finding that the claimant being a self-employed earned rupees 1,20,000 per month. For the above reason, this could find that the income certificate cannot be accepted without being proved, and the court find that the claimant is as 29 years, and that it would be appropriate to fix the notional income of the claimant as rupees 6,000 per month, considering the fact, and there is absolutely no detail as to the nature of this private business or the nature of the income received by the claimant on being an agriculturist.
Okay, okay.
And
Then second one?
Second one, para number 11, that's it. insofar as the determination of the compensation is concerned, the tribunal has awarded a total compensation of rupees 12,43,324 with interest at rupees 600 per annum. Do that appellant would vehemently contest the compensation awarded by the tribunal is evidently on the oversight. It will be elaborated his submission by content that deceased was engaged in agricultural farming and used to rupees 10 lakh to rupees 20 lakh annually. We are unable to accept the said conditions for the reason more. And the firstly, claim regarding the income analysis as pleaded cannot be accepted for a simple reason that apart from the self-assertion of the appellant, no documentary evidence whatsoever has been placed on record to establish the same. Even if it is accepted that the deceased was earning income by carrying an agricultural operation, and due to his death, income from the agricultural land is not lost. The agricultural land has remained with the claimants, and the most claimant would be entitled to compensate for supervision such that may have the incur in carrying out the agricultural operation. Like this lawsuit, his vehicle will be intact. His vehicle will be intact, but for the managerial person, some person may be required. But income from the vehicular business will come to the claimants.
Lordship, in this regard, I am relying on two judgments. One, the Honorable Tripura High Court, and another is of this Honorable Court. Lordship, so far as judgment of Tripura High Court is concerned, Lordship, kindly see paragraph 4, Lordship. I do not find that the tribunal has committed any major error. Estimation of monthly income of 12,000 from an electronic shop can hardly be stated to be excessive. The tribunal has relied on the sale data produced on record and estimated a fair profit rate on the turnover of the sales. The contention of the counsel of the insurance company that the major sons would be well looked after the shop cannot be accepted. As an experienced shopkeeper, even if the sons were to take over the business, the profitability of the business would go down. If the deceased was alive, with the help of his sons, the family could have expanded the business or even set up another shop. And another judgment also, though it is not proper in form, if required, I will submit certificate copy with the same. Gauhati High Court, Lordship. It is marked as paragraph 4, Lordship. It is marked.
What you are dealing?
Lordship, I'm reading. Same point, Lordship.
Okay.
It is in the evidence that the deceased was doing business, doing wholesale business, and he has also transport business. The nature of business is that it requires high degree of professional skills and public relations. The nature of business is not as such that anybody who continues the business after his demise will have some amount of
on same ground.
good income, Lordship. If required, Lordship, I will submit the certificate copy.
Okay, heard Mr. K.K. Bhattu, learned counsel for the appellant. Also heard Mr.
M. Talukdar.
Mr. M. Talukdar, learned counsel for the. How many respondents are there?
He has appeared for the respondent 1 to 4.
1 to 4.
Learned counsel for the respondent number 1 to 4. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the Reliance General Insurance Company Limited, impugning the judgment and award dated 8/10/2021, passed by the Motor Accident Claims Tribunal, Silchar, Kachar. Motor Accident Claims Tribunal, Kachar, Silchar, in MSC case number 122/2019, whereby the appellant was directed to pay a compensation amount of rupees 29,27,000 along with an interest of 7% per annum from the date of filing of the claim petition till realization to the claimant's respondents. The facts relevant for next para. The facts relevant for consideration of the instant appeal, in brief, are that on 23/8/2017, the who died?
Husband of the respondent number 1.
The husband of the
Respondent number 1. and
respondent
father of
number
respondent
1.
2 with 3 and 4.
Respondent number 1. Namely, what was his name?
Tulu Vaishnav.
Tulu Vaishnav was going from Kalayan side towards his house by riding a motorcycle bearing registration number AS11B 7049. Stop. When he reached Khelma Part 4 near Gumra Bazaar at National Highway number 6, all on a sudden, a truck bearing registration number AS01BC 1759, which was proceeding from the opposite direction and was being driven in a very rash and negligent manner by its driver, hit the victim, hit his motorcycle. Stop. As a result of the said accident, the husband of the respondent number 1, sustained grievous injuries on his person. Stop. He was immediately shifted to Kalain Hospital. However, the doctors informed declared him dead in the hospital. Thereafter, the present respondent number 1 to 4 had approached the Motor Accident Claims Tribunal, Kachar, Silchar, by filing an application under Section 166 of the MV Act 1988 seeking compensation for death of Tulu Vaishnav in a motor vehicular accident. The present appellant, next para, the present appellant, being the insurer of the offending vehicle, contested the claim of the present respondent by filing a written statement. Stop. on the basis of the pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Quote A from page 13. Following issues. Next para. In order to prove their case, the claimant sides examined the claimant number 1 as PW1 and exhibited about 19 documents. The insurance company did not adduce any evidence in defense. So ultimately, by the judgment and award which has been impugned in this appeal, the Motor Accident Claims Tribunal, Kachar Silchar, had allowed the claim petition filed by the respondent claimants and directed the present appellant to pay compensation to the claimants in the manner as already described in the foregoing paragraphs of this judgment. Stop. Next para. Mr. K.K. Bhatta, learned counsel for the appellant, has submitted that the appellant insurance company is aggrieved mainly with the quantum of compensation awarded to the claimants. He submits that the tribunal wrongly assessed the annual income of the deceased as wrongly assessed the income of the deceased at rupees 19,500 without there being any basis for same on record. He also submits that the tribunal also erred in relying on the income certificate issued by the circle officer and which was exhibited as Exhibit 16. He submits that in the said exhibit, it was stated that the deceased was doing stone business, whereas the claimant...
So this is stated in stone business and others.
Stone business and others, whereas the claimants have themselves claimed that the deceased was doing the business of vehicles. He submits that this contradiction has not been taken into consideration by the Motor Accident Claims Tribunal while assessing the income of the deceased. He also submits that the claimant side had failed to produce any document apart from exhibit 16, apart from exhibit 16, like the trade license, the GST certificate, and what else, Mr. Bhatta?
Bank statement.
bank
Bank
statement,
statement, book of accounts and income tax return.
book of account, or income tax records. And the tribunal therefore arrived at a wrong conclusion while assessing the income of the deceased. So he submits that in absence of any concrete proof regarding income of the deceased, the trial court ought to have assessed the income of the deceased at rupees 8,000 per month. In support of his submission, learned counsel for the appellant has cited following rulings. Deepak Kalita versus Divisional Manager and others, reported in 2025 Legal Eagle within bracket GAU 153, number 2. Suhag Rani and others versus Manager Cholamandalam Messrs. General Cholamandalam MS General Insurance Company Limited, reported in 2025 10 SCC 2024. He also submits that since the deceased was owning 2 trucks, even after his death, the income could have been generated from the said trucks by the claimants, and thereby no loss of earnings would have been there. E paragraph 2 citation or uparat loi jabo. Stop. On the other hand, Mr. M. Talukdar, learned counsel for the respondent claimants, has submitted that there is no infirmity in the judgment so as to warrant any interference in the same by this court in this appeal. He submits that the trial court, after considering the evidence on record, has calculated the income of the deceased. He also submits that the income of the deceased was not assessed by the Motor Accident Claims Tribunal on the basis of Exhibit 16. Stop. He submits that in Exhibit 16, the annual income of the deceased was shown as rupees 3 lakhs, whereas as per the income assessed by the tribunal, that is rupees 19,500 per month, the annual income comes to rupees 1,80,000 only.
But calculation may be something else.
No, if let's see,
19,500.
if let's see 15,000 monthly income is considered, then 1 lakh.
19,500 into 12. It comes to 2,34,000.
2,34,000. Stop. He also submits that the trial court, while assessing the income of the deceased, took into consideration that he was the owner of 2 commercial heavy goods vehicles in addition to motorcycle, and it was assessed by the Motor Accident Claims Tribunal that on the basis of his possessing 2 commercial heavy goods vehicle, his daily income would be 650 only, which according to learned counsel for the respondents was on lower side. He therefore submits that the Motor Accident Claims Tribunal has correctly assessed the income of the deceased, though on a lower side, and therefore same need not to be interfered with by this court. He also submits that
Lordship, in affidavit paragraph 4 specifically mentioned that the two vehicles were used for carrying bricks and stones.
okay. He also submits that the contention of the claimants before the claims tribunal that the deceased was doing the business of vehicles, as well as the certificate produced by them, which was exhibited as Exhibit 16, wherein the circle officer has mentioned that the deceased was doing business, stone business, is not contrary to each other, inasmuch as in her evidence on affidavit, the PW1 has specifically stated that the vehicles were used for carrying stones and bricks, etc. He also submits that the contention of the learned counsel for the appellant that the claimants could have used the trucks for generating the income, and therefore there may not be any loss of earning on their part, is also not may also not be acceptable, inasmuch as the respondent number 1 is the wife. And who are the other respondents?
Two is son, 23 years old at that time, and 3 is daughter, 19 years, and 4 is son, 17 years.
And the other respondents cannot be regarded as expert in doing the business which was carried out by the deceased.
Yes, number 2 and 3 are the measures on and without.
Stop. He, in support of his submissions, learned counsel for the respondent has cited following ruling. Cholamandalam MS General Insurance Company Limited versus Jharna Rani Debnath and others, reported in 2019, legal within bracket TRI 697. Next, Oriental Insurance Company Limited versus Sulochana Devi Kayal and others, within bracket judgment dated 23/4/2014 in MAC appeal number 96/2009. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. I have also gone through the rulings cited by learned counsel for both parties in support of their respective submissions. In this appeal, where the insurance company has is claiming that the quantum of compensation awarded to the claimants is on the higher side, and that the assessment of income of the deceased was not correctly done by the Motor Accident Claims Tribunal, comma, as the tribunal relied on the report of tribunal relied on the income certificate issued by the circle officer. Stop. However, comma, on bare perusal of the impugned judgment, it appears that the tribunal has not relied upon the quantum of the earning mentioned in the tribunal has not accepted the annual income stated in the Exhibit 16, which is the income certificate issued by circle officer. Stop. Rather, it appears that it has not relied on the same, but relied on the other exhibits, that is Exhibit 17, 18, and 19. It also appears that Exhibit 18 and 19 are the registration certificate of the two commercial heavy goods vehicle of which the deceased was owner. And on the basis of the said ownership of the said vehicle, the tribunal assessed the daily income of the deceased at rupees 650 per day, which by any count, comma, in the considered opinion of this court, appears to be on lower side. Lower side. Stop. Any other issue? Hence, this court does not agree with the submission of learned counsel for the appellant that the assessment of income of the deceased by the tribunal in the impugned judgment was wrongly done. The rulings cited by learned counsel for the appellant in the considered opinion of this court under the facts and circumstances of this case does not come to aid of the appellant. Stop. This appeal, therefore, is found to be devoid of any merit and accordingly dismissed. Send back the trial court records. Send back the records of the Motor Accident Claims Tribunal.
The statutory amount may be.
Tribunal along with the anything along with the copy of this judgment.
The amount may be deposited before the learned tribunal within a certain fixed period.
The statutory amount may be allowed to be withdrawn by the claimant, appellant.
When will you deposit the?
We can deposit it here also before the registry.
Before the learned tribunal.
Within 2 months?
Within 2 months.
Long.
6 weeks.
6 weeks.
Within 2 months, it is better. I'll accept.
Okay. Because it will carry interest also.
That's it.
Till payment, it will carry interest. So you will not.
Let it be deposited before the registry of this court.
No. Let it be there. Claimant will be in a better way. Otherwise, from Dhubri, they have to come here.
No. They have not to come here. The process is something different. They have to verify there. And amount will be released from here, from the registry. It will be in the account of the claimants. Whatever lordship order may pass. If your lordship wishes to deposit the same, direct deposit the same before the learned tribunal, it's okay. Lordship.
Or if say no observation is made in that regard, still they will have to pay.
Lordship, they will delay the matter.
There will be delay. The appellant insurance company is directed to deposit the awarded amount before the registry of this
Minus the amount already paid.
awarded amount. You have deposited 50%.
Yes, that has been withdrawn.
Deposit the awarded amount minus the amount which has already been deposited by the insurance company before the registry of this court within a period of 2 months from the date of this
6 weeks,
judgment.
Lordship. For the registry, Lordship.
2 months from the date of this judgment. And that is the outer limit. On receipt of the said amount, the registry, after proper verification, shall disburse it to the account of the, shall deposit the same to the bank account of the claimants. This make appeal is accordingly disposed of.
Statutory amount may be released.
The
directly.
statutory amount deposited by the appellant may be returned back to the appellants.